Okay, well, thanks for joining this webinar. This afternoon, we're going to have a look at the Information Commissioner's accountability and a framework and what that means from a GDPR compliance point of view. As a sort of potted summary, I guess, it's pretty broad in terms of the areas of GDPR it covers, but then so is accountability. And there is quite a bit of detail and quite a lot to cover. So I've picked out the main elements, which is the majority of them. Things are slightly summarised in a slightly different way than the ICO set out in the framework, but everything is covered. I will go through the various different elements in the presentation, and then, as I say, if you've got any questions, then feel free to ask at the end or use the chat, and I'll try and pick those up as I go through. So for anybody who doesn't know me, my name's Mark Gracie. I run Mark Gracie GDPR and support businesses with their GDPR compliance, and I do that through being an outsourced data protection officer to carrying out reviews and audits to supporting very specific things, and I run a helpline as well. That's me. I'm not going to read that slide. I'll leave you to read that in your own time, and I'll supply a copy of the slides when I distribute the recording as well. So what we're going to cover, well, as I said, we're going to cover the ICO's GDPR accountability framework. Look at that in a bit of detail, and think about some of the things that you I've got a small checklist of things that if you've not already been looking at it, you need to sort of think about next steps, as it were. But let's start with a brief background and introduction. Hopefully, I don't need to introduce the GDPR too much, but this slide is a sort of a top level summary covering the basics of GDPR. Accountability fits in there as a separate area because it's an important part of GDPR. It's something that the ICO recognised in the last year or so that probably people need to do more work, which is, I'm guessing, why they've decided to publish a framework. But it was a new principle that was introduced with the GDPR that in essence says you've got to prove your compliance, and it sets out various things. There's a bullet point list there of different things like whether or not you need a data protection officer, documentation, training, policies, due diligence on third-party data processors, data protection, impact assessments, code of practice, dealing with breaches, all those kind of things. So essentially the framework has taken that accountability principle, looked at what things ought to be considered, and this is what the framework is presenting. So that's where accountability fits into GDPR. It is one of the data protection principles, but very much sort of stands alone as a key element of any GDPR compliance. Now, in the introduction to the framework, to answer the question why have a framework, just highlighting what I said already. The Information Commissioner's Office feels that accountability is a key principle about making sure that you're demonstrating your ability to comply with the law, and making sure that you're responsible for that compliance. And the sort of one of the key things about GDPR in general is, of course, it doesn't matter whether you're a small or a large business, it applies. Yes, there is some balance to be made about risk, and if you're a small business with very few customers, then that's a lower risk in terms of chances of things going wrong than it would be if you're a large business processing lots of customer data. Equally, that risk may vary if you're processing special category of data, and so forth. And this is recognised also with the accountability framework. The ICO very helpfully make it clear that actually it doesn't matter whether you're small or large, this accountability framework should help, but scattered throughout it is basically that risk assessment element. So if you're a small business, you possibly don't need to deal with a lot of the detail, but you can probably take an overview approach, and I'll sort of touch on what those things might be as we go through. if you're a big business, you'll be expected for sure to follow the principles of the framework. Now, the framework itself has 10 key categories, and we're going to work our way through all 10 of those, I'm afraid, and sort of talk about some of the detail. They range from everything from your day-to-day governance, the way you manage your data on a day-to-day basis, right through to dealing with things like individuals' rights and breach responses, and throughout is littered little bits of evidence of what the ICO would expect to see should they come knocking one day and asking you to prove that you're GDPR compliant. And I think that's probably the key thing here, is that the framework across all 10 categories is giving you an insight into what the ICO is expecting in terms of compliance. And if you do get on the wrong side of the ICO, either because somebody's complained about you, or they're investigating you for enforcement action, or indeed they decided they wanted to audit you, because they do consensual audits, then this is giving you some clue as to what kind of things they would expect to see. And just by example, we're looking at in the breach area, in the record management and security area, there are elements there that reflect what they basically told British Airways last week when they fined them 20 million, in terms of not having proper access controls and not monitoring what is going on their network or on their services. Otherwise, they may have spotted the intruder within their systems, which led to the ultimate breach on their website. So yeah, so I think that the biggest takeaway from all of this is that this gives you clear insight into the ICO's thinking and its interpretation and expectation around certain elements of GDPR, and covered in those 10 categories are essentially the core elements of GDPR compliance. So in the introduction, the ICO go into a bit more detail and say, well, what does this help you do? Well, as well as understanding the ICO's approach, which is that second bubble there as you go around clockwise, it should help inform a privacy management program within your organization, help you find areas of improvement, show you how to demonstrate your compliance, how you need to record and document that compliance, and how you need to make sure that there is proper awareness across your business so that everybody understands their responsibilities, and also how to carry out those responsibilities, and what to do if things go a bit wrong. So that's the sort of the basic introduction of the framework. So let's look at the framework in much more detail. So I'm going to work my way around those 10 bubbles, and I've got a diagram with the sort of the summary and some text on the side, which you can obviously read at your leisure when you get the slide pack. So the first thing in the framework is about leadership and oversight. In essence, this is about the governance or the information and data protection governance within your organization. It's about meeting the requirements of ensuring that somebody is taking responsibility for data protection compliance, and that is maybe that's possibly across multiple levels. So at the top you have the senior management team, the board of directors, the chief executive, the managing director of a small business, or however you're structured, who are ultimately responsible and should be taking steps to ensure that these sort of things are in place. They won't necessarily be doing the day job. That may be down to a data protection officer, mandated or otherwise, or it might be down to a single point of contact. But it is all about a governance structure within your organization, and that governance structure should be documented internally, so that people understand that they have a general employee has basic responsibilities, but ultimately the data protection officer, manager, or whatever you call that single point of contact, takes ownership of making sure things are compliant and reports that to the senior level of your business, whether that's a senior employee, a management team, a board or whatever, depending on the size of your business, of course. If you're mandated to have a data protection officer, so you'll know that GDPR says that certain types of organizations need to have a data protection officer, then you have to make sure that that data protection officer meets the GDPR obligations. So GDPR essentially says what the characteristics of that person should be about their knowledge and their understanding and their ability to interpret the rules and enforce that within the business, but it also gives guidance to the business to allow that data protection officer to do their job. In the past, I've jokingly said it's basically the bit of the law that makes sure that the poor old data protection officer doesn't get told to sit in the corner and be quiet, and is actually allowed to get on and do their job. If you're not mandated to have a data protection officer, then the ICO expect you to be able to prove the reasons why. So in some ways, well, there's three kind of core areas that require data protection officers: public body, large processing of special category data, large processing of data that enables you to monitor behavior of data subjects. If you don't do any of those things, then you probably don't need a data protection officer. But the idea from the ICO's point of view is that you have a documented reason as to why that's the case. Now, that can be just in a data protection policy saying our data protection lead is this person. We're not mandated to have a data protection officer because we're not doing any of the three key core things that require a data protection officer. And I've always said, certainly when I work with clients and people I talk about when I talk about GDPR, is even if you're not mandated to have a data protection officer, you should have somebody who is the lead person responsible for GDPR compliance, because you want to make sure that that compliance is maintained. And this element of the framework is all about, essentially putting that organizational structure in place and reflecting on having a single point of contact for data protection, whether mandated, in which case you'd have a DPO, or whether not mandated, in which case you might call them a DPO, but they're not mandated. It might be a data protection manager, data privacy champion, or whatever you want to call them. The expectation is also that you have processes in place to ensure that you treat data protection compliance like you would any other project. So that is an expectation that in terms of the wider overview or oversight, as the ICO called it, of GDPR compliance is managed within a project team, and there is a formal process to that, maybe led by the data protection officer, recorded in keeping a risk register or an action register of things that need to be done, minuted and so forth. And this is all part of that governance structure to highlight that data protection is being treated seriously within an organization. Of course, if you're a one-person business, you're essentially all of these things, and this is somewhat overkill. It will be pretty obvious that you, as the sole trader or the freelancer or the director of a very small business, are the senior management team, probably the data protection responsible person, and therefore holding meetings with your team is probably more about making sure they're educated about data protection. So you probably wouldn't be expected to have a data governance project team, for example, but you are expected to at least understand and interpret this accordingly to the size of your business. So ultimately, as always, everyone has a role to play in data protection, but it's about structuring your organization in a way that everybody understands who they need to go to, which is typically the data protection officer or manager, or whatever you call them. But ultimately, that individual, that single point of contact, reports higher up the hierarchy of the business, if there is a hierarchy, to make sure that ultimate responsibility lies with those who are ultimately running the business. So have some kind of documented organizational structure where it's appropriate. Have somebody take the lead responsibility for data protection. If you don't need a data protection officer, then you should have a single point of contact anyway. Make sure there's an appropriate reporting line on data compliance matters. Manage it like a project, like you would anything else, and monitor that and keep that flowing to make sure that you continue to maintain your compliance, and just make sure that there is general oversight of what's going on within your organization, and it's documented. So that's the first category, leadership and oversight. Next one is about policies and procedures. So I always talk about, when I talk to people about GDPR, that how can you prove your compliance if there are certain things not in place? And one of those is policies and processes or procedures. You need to have a policy framework which reflects the kind of processing that you carry out, reflects a number of different areas of that processing and the expectations of yours, roles and responsibilities as far as GDPR is concerned. So that could be, you have a main data protection compliance policy, which is an internal policy for your organization, setting out your basic data protection compliance and what data GDPR is about and how it applies. But you would also need an array or a suite of other policies covering other elements, how to deal with individuals' rights, how to deal with a data breach, how to manage marketing data, and so forth. So you will need to make sure you have these internal policies. And just like the previous slide, when I was saying about small or even single person businesses, of course, you're kind of writing and having a documented policy and process for yourself. So maybe that's a bit overkill, but at a very basic level, make sure you understand how you are, what you can and can't do with data, and you're clear in your own mind in that scenario where it's just you about exactly what it is that you need to be doing. If you have a team of people, then you need to make sure that those policies are accessible and known to your employees, that it sets out exactly who takes responsibility for data protection. So that's where you can document your hierarchy of roles and oversight, so the governance side. Make sure these policies are reviewed, because law does change from time to time. There may be elements of enforcement actions which may mean you need to update certain things in terms of, say, things like data security and expectations accordingly. You need to somehow make sure employees read and understand. Some businesses get their employees to sign that they've read and reviewed a policy. How you do that is up to you, but it's about really what is actually coming on the next slide, about them understanding the basics and giving them training, and that's cross references into the policies. Make sure that you are reflecting your processing activity. If you're dealing with particularly special category of data, you probably ought to have either a massive part of the main policy about that, or you have a separate policy document that says that. For example, you need to make sure that other processes across your business are updated to reflect some of the GDPR requirements. So if you have a structured approach to delivering projects, or you have a procurement exercise procedure which determines how you choose suppliers, well, there needs to be if this supplier will be ultimately a data processor, then you must do these things from a GDPR point of view. You need to get the DPO to carry out due diligence, for example, and make sure we've got a contract in place and all those kind of things. So you'll need to look wider than your data protection policies, but it's about those processes and procedures where personal data is linked to whatever that activity might be, and you need to update those as well. And then right at the bottom there on that list on the right hand side is some extra notes an extra care needs to be taken when you're dealing with children, and that needs to be sort of fitting in with the age appropriate design code that the ICO published earlier this year, and the requirements about processing children's data as well. So essentially it's all about policies and procedures. Document everything internally about how you're going to be managing data. Make sure that you bake in privacy by design, data protection by design and default into new projects, into making sure that things like due diligence on processes is considered as part of procurement exercises, and so forth. So that's probably not too much of a surprise to most people. Policies are usually the best way forward in terms of having an internal process around everything that you need to do. The other part of my kind of triad of three things you really ought to do. You've got your policies, the next one is training, because if you don't have policies and you haven't trained your staff, how can you demonstrate that you are GDPR compliant as an organization? Because your staff won't necessarily know what it is that they're supposed to be worrying about. So this category of the framework is all about the training and awareness. It's making sure all staff are trained, that new staff get training as soon as possible before they start doing any kind of processing of data or using systems where there's personal data, that the training is refreshed probably once a year once a year in a lot of cases. Sometimes for smaller businesses, maybe every couple of years, but you need to make sure you constantly remind people about the way that they are interacting with personal data. And in fact, actually, that just reminds me of something I didn't say on there. It's one of the elements here with policies and procedures. There are other ways in which you can set out what you should or shouldn't be doing, and the ICO suggests things like posters, internal communication, team training, and things like that as things that you can also do, and that's also true for training and awareness. The awareness angle is more than just training and internal policies. It's about how do you keep that constant communication working with your employees so that they're on board and constantly reminded. And if there's a internal communications, then you might want a GDPR section of that goes out every quarter or every month, just to keep that flow of information going. So training for everybody, training for new starters, refresh training for everybody at an appropriate interval, which, as I said, is probably once a year. But you should also look at, are there certain areas that need very specialized training? So when I've worked in organizations dealing with data protection, there would be a company-wide training session that covers the basics. The understanding that this is what data protection is about, things to look out for, don't suddenly start using processes without checking them out first. Make sure you understand what a subject access looks like, make sure you spot what a breach might look like, and so forth. But there may be teams within the organization who may need more additional training. So marketing people might want or may need specific training about what you can and can't do with marketing data, where GDPR fits into that with regards to consent, for example, and unsubscribing and withdrawal of consent, how the privacy electronic communication regulations apply alongside GDPR and so forth. Your customer service teams may need specific training to understand the nuances about making sure they're talking to the right people, that they're not recording stuff in systems which is derogatory, that you would be embarrassed to have to disclose as a subject access, and so forth. So as well as an all staff training program, you need to look at who within your business, what teams could do with more detailed or very specific pointers as to how they could be GDPR compliant, and then ultimately make your organization GDPR compliant as well. But doing the training is one thing. There's pros and cons for doing in-person training. It can be quite costly. There's pros and cons of using online systems, in that people can quickly skip through things as long as they get the answers to the end of that particular section of the online training, ticked and passed the pass mark, then that doesn't necessarily mean that they've paid attention. But you need to work out how you're going to deliver that training, and that's going to be down to a combination of what works best for you, and also where you see the risks are in terms of getting this bit right. And if you do training, you need to make sure your employees were paying attention. So have some kind of testing mechanism after the training event. Either if you do use an online system, often there's a training element, testing element of part of that. If you do in-person training, then you might want to do a post-training session quiz or something like that. Keep a record of who's been training, not least of all to be able to spot people always off sick or on holiday when you plan your training. But that is evidence that you've addressed 95% of the workforce have had data protection training over the last 2 years or whatever. But it's a documentary evidence to prove that you have carried out training, and that a majority of your team, if not preferably everybody, has been along to that training. As I said before, also look at other ways you can maintain the education about data protection, so like internal communication, posters on walls, that kind of thing, specialist training for team meetings, and finally, probably the other thing is sort of it's not really there as a bubble in this category, but the ICO make the point of getting feedback from the employees. Was there bits that they didn't really understand but didn't ask? If you don't know about the effectiveness of the training, then how are you going to know that it's worthwhile you delivering it next time around? You might need to update things, and there may be sections that people didn't really understand, and so forth, or bits that they want more detail. So you're expected to get some kind of feedback in place so that you can assess the effectiveness of your training program. So that's training and awareness. When it comes to individuals' rights, so these are the rights of the data subjects. That covers everything from data subject access requests through to the right to be informed, the right to object to processing, the right to erasure, portability, and so forth. There's a number of elements, as you can see, quite a few actually, within this category of the framework. When it comes to meeting the requirement for the right to be informed, then make sure that everything is in place that you need to have in place with regards to privacy policies and transparency is the next slide, so I won't dwell on that too much. But it's about delivering the right privacy information at the right time, make sure people understand how they can exercise their rights and so forth. Policies and processes and training in place to make sure people understand how to deal with individuals' rights. If necessary, train people who are going to be dealing with these more often than not to make sure that they understand. If you've got somebody who's taking responsibility for data protection, if they're a data protection practitioner, then of course you would expect them to understand that. But if you've got somebody who's standing in or has been nominated, but this isn't their day job, then you might need to give them more specialized training about understanding what they can do, and that can be backed up by the policies as well. You are expected to make sure you've got sufficient resources in place. You can't just argue, well, we weren't anticipating 10 data subject requests this month, and therefore we didn't have the manpower to deal with them. The GDPR expects you to be able to deal with them and adjust your manpower accordingly. You should have checklists in place that set out where data can be found, what can be searched and so forth. So when you're looking for stuff, you're not missing data areas. So if you've mapped out your data, and we'll talk about some of the documentary requirements in a minute, like recording processing activities, you should in theory be able to build quite a clear checklist of all the places where data is across your organization, and you just need to make sure that you've got that in a way that the person dealing with the request is able to identify and locate the data as easily as possible. You need to include summaries and reports to senior management so that they understand what's going on and that the processes are working. You also need to keep a register of these activities that you might be carrying out to meet these rights, so that you can identify any trends, like there's been a sudden rush of subject access requests just after Christmas. Why is that? Is there something we can do to try and limit that? Is there a problem with requests aren't being dealt with until the last minute, and is there something that needs to be done with that, and so forth? And so going back to that first slide about the governance side of thing, it's about having the documentary evidence, but also reporting up the governance chain about what's going on and managing that risk and those things that are going on within your compliance team, or your compliance project team, for want of better words, if you put one in place. But I think essentially GDPR tells you what you got to do with individuals' rights, so there's not any big surprises in this particular area of the framework, I don't think. Now, in terms of transparency, this is about providing information to data subjects about how you're using their data, so the right to be informed, and how that sits with providing everything that they should know. So that's making sure they understand what needs to be covered making sure you understand what needs to be covered in your privacy notices, make sure that it's delivered in a timely way. So that's about signposting it at the right points. It may be delivering it as part of a process that they may be going through, whether that's signing up to something or as part of you delivering your product or service. So for sort of relating that to the age-appropriate design code for services aimed at children, there is an expectation, for example, that you will, if somebody switches something off in a privacy intrusive way, that they're warned, that they understand what they're actually allowing to happen and so forth. And so you've got to look at that. Whilst that's just a children's data perspective, you need to think about that in your system or your service to make sure that privacy information is delivered at an appropriate point, but also given in a way that alerts people to potential implications of what they might be changing. It also means providing it in a way that best provides that information in a simpler way as possible, and in language and in ways that can be understood. So if you're, sorry to use children as an example again, if you're delivering privacy information to children, then you must make sure your privacy statements are understandable to a child and written in a way that the child would be able to reflect. They probably reflect and know about the data and how their data is being used. They probably won't engage with you if you use technical terms like subject access requests and don't explain what that means. But if you explain in simple terms what all these things mean, then you're seen to be delivering it in a way that is effective for the audience of the notice. You need to make sure that staff understand what the transparency principles are about, when they should or shouldn't be delivering information and explaining, signposting and so forth. So if you have a script-led sales process, you need to make sure that your scripts have the right point at time in explaining how data is used and so forth. You need to make sure employees know exactly where the privacy information is. So it's not so much about just being aware that they need to tell people, but actually where they can find it and how they can deal with inquiries. What privacy information is provided should tie in with any register of processing activities, because the processing activity register or the record of your processing activities will highlight the data subjects, and your privacy information needs to be available to all of those different data subjects. A common example of what I see a lot of is people have a privacy policy on their website which says, when you access our website, we use cookies, and doesn't say much more than that, other than some of the core basics of a privacy policy. So you then need to think, well, when somebody rings up our customer services team, how will they know what happens to that information that they may give at that particular point? The verification that they're talking to the right person, how they will document whatever the conversation was about, if you've got a system that you might record notes on, and all those kind of things. So if somebody says, well, I'll go and look at the privacy policy on the website, but the privacy policy in the website is just about what happens if you access the website, then that's not provided the transparency that is expected from GDPR. So it's about understanding that you know whose data you're processing, and your privacy policies reflect that. Now, something I found quite curious, and somebody might pick me up on this and say, well, it seems pretty obvious, but the ICO actually encourage you to review. Well, I'd recommend that myself, so that's nothing new. But the thing that I hadn't quite picked up on was an expectation, which is in the framework, that you should keep basically a historic log of your different privacy policies. So don't overwrite your privacy policies and throw out the old ones. You need to keep a set of historic privacy notices that are dated, and it's obvious where they've been placed and so forth, and that's so that if somebody does come, or say the ICO take 2 years to investigate something, they can say, well, this is the privacy policy that was served at that particular time. So you need to have that evidence available as well. You need to understand if you're receiving complaints about privacy, or if people are constantly telling you that they didn't realize you're going to process their data and they're not very happy about it. You need to analyze those to make sure that your processing your privacy notices are in line with addressing whatever the concerns may be that are being missed in the privacy notice, or indeed that you're picking up on any particular challenges around the transparency or indeed any kind of data protection complaint. So as well as reviewing your privacy policy, you should be doing some internal checks to see, are people complaining about not knowing what we're doing with data, in which case we probably need to make changes to the privacy policy. And then finally, tools need to be applied where possible to allow people to change settings relating to how their data is used. So, certainly in marketing terms, we talk about having preference settings that you can say you opt into certain types of marketing, and you can do that by going to a part of the web page or whatever, or your account, and doing that. Where that is relevant to your business, you need to have these tools that support the transparency and have privacy turned on by default within your application or whatever it is that you're offering, where that's relevant. Obviously, if you're selling widgets to somebody, you just need their name and address so you can send the widget. You probably don't need to worry about that too much. For smaller business, I think all of that should be hopefully pretty obvious for larger business. For smaller businesses, the key is get your privacy policy right. Make sure you deliver it at the right time, so that anybody you interact with is able to understand how their data is being used and processed, and make sure that you review it to make sure it's up to date probably every year, to ensure that you're covering all those data subjects, particularly if your business changes or you do things slightly differently over time. So that's transparency. That's about the privacy policies and the right to be informed. So we're at halfway point now. The next category is about records of processing activity and application of the lawful bases. So lawful basis for processing, of course, is things like consent, contract, legal obligation, public task, legitimate interests, I've forgotten the word. In the interest of the data subjects, that's what I was trying to say. So this area of the framework covers two areas. One is your record of processing activity, and the ICO suggests you carry out a data mapping exercise to work out where in the organization and how data is processed, and then you have that backed up as a record of a processing activity, or the ICO refer to it as I don't know if they call it a ROPA, but an ROPA. So you have an electronic record of processing activities. This is a GDPR obligation, so everybody has to do this. If you're over 250 employees, you have to record all processing activities. If you're under 250 employees strong as a business, you only need to record the regular processing activities. But your record of processing activities, the ICO provide a template you can use, is basically the documentary evidence that you know what data is being processed, what kind of data about what kind of subjects are being processed, where in the world it is, what lawful basis you're relying on, what security is in place, and so forth. So this should be no surprise to anybody, because we all have to have these records of processing activities, and the idea or the concept is if the ICO ever came knocking and they asked you for it, you would have it ready to hand over. They obviously won't be very pleased if you say, hang on, I'll get it to you next week once I've drawn it up. So the ICO suggests carry out a data mapping exercise to understand how data is flowing around your business and where it is, and then document the actual types of data in your record of processing activities. Make sure you're recording everything from the lawful basis, your retention schedule, the location of the data, what processes you might be sharing the data with, and so forth. This is all the kind of things you would expect, so that shouldn't be really new. Make sure that the lawful basis is identified correctly and recorded. And if you're processing special category or criminal offence data, then you'll need to make sure that you choose the right special condition. So that's Article 9 for special category or Article 10 for criminal offence data. Or if you're relying on a Data Protection Act 2018 in the UK, exemption. So, for example, if you're processing employees' health information because they tell you about sick leave and things like that, then you would be relying on the special condition for employment and the equivalent in the Data Protection Act 2018. When it comes to different types of lawful basis, if you're relying on consent, then there's very specific GDPR requirements about what that looks like, and one of those is about having evidence of how consent was collected in the first place. So that might be providing copies of or keeping copies of online forms, or the wording you had, and the mechanism by which somebody would have signed up. So I often get, well, can I collect consent verbally? You can, but you need to be able to demonstrate that you have a process in place that includes the getting the right consent mechanism, or the message across, and making sure that the consent mechanism is working. You need to review that consent and make sure that it's still relevant and necessary, and if necessary, review it at appropriate intervals. The ICO generally have talked in the past that in terms of what an appropriate interval might look like will depend on the circumstances. If you're renewing data on a regular basis, like you're renewing some kind of contract annually, then that's probably the time to refresh consent if you're relying on consent for anything at that particular point, but it shouldn't be any longer than every couple of years. You need to provide functionality to allow people to manage their consents if possible. Obviously, that varies on the whatever it is that you're doing. There are some additional checks and balances when you're dealing with consent relating to children under the age of 13 that needs parental consent as well. So the expectation is that you, where you need to, you're carrying out age checks which enable you to identify the age of the child, so that you can then get parental consent as well. And then there is you need to basically manage and this whole process, but also review it on a regular basis, probably annually, to make sure that things haven't changed in terms of what you're processing and how you're processing it. But if things are quite fluid within your organization and things change quite a lot, then you should really be updating your record of processing activities as things happen. That includes reviewing that your lawful basis is still relevant, and that you are not storing data that you don't really need. So you're meeting that principle of data minimization and data retention. And if you're relying on lawful basis like legitimate interest, as well as consent has some checks and balances, legitimate interest has the 3-point test that requires you to prove that legitimate interest was indeed the most legitimate lawful basis for you to use. So there is a thing called a legitimate interest assessment that you can use as documentary evidence of that. So that's basically recording the data you're processing, how you're processing it, why it's lawful for you to do it, and some checks and balances around things like consent and legitimate interest that's proving that you've considered those very carefully and that you're acting lawfully. So that's records of processing and lawful basis. When you're dealing with third parties, you might be using a data processor, and always remember a wide definition of data processing means that it's not just what you've got the data for in the first place. It could be editing, deleting, sharing, manipulating, or whatever, where you're if you're using a cloud-based service like a CRM or accountancy package, then they may be considered data processors depending on what you're doing with that package. If that's the case, then there are strict rules in Article 28 of GDPR about what you can do with data processors, but also you may be sharing data for other reasons. You might have a relationship with an organization, or you may be obliged by something that you do, maybe a public task, for example, requires you to report to the government or local council. So certainly in terms of education, for example, that tends to happen. Then you need to have certain protocols in place regarding to data sharing. So this element of the framework is about the contracts and the data sharing elements of what you're doing with data. And it's also about some other extra different things as well, like restricted transfers. So essentially what the ICO expects in this contracts and data sharing part of the framework is that you have a process in place that when you do share data, you carry out some kind of risk assessments. That might be a data protection impact assessment. There's documentation about your approach, that it's clear who takes authority or gives the authority to allow that data sharing. That might be a data protection officer, it could be the senior management team, but you're essentially got a protocol in place that before you start sharing things, you carry out a certain set of activities to make sure that it is lawful. One of those activities, of course, is reviewing data sharing agreements and making sure that both parties, you and third parties you're sharing with, meet the requirements and the sharing obligations. You need to keep a log of those so that you can clearly demonstrate you know which sharing agreements you've got with whom. You need to understand where in the world the data is being processed. So this is the restricted transfers element of this. So this is about having an appropriate safeguard for any processing outside the European Economic Area. There's obviously some Brexit challenges about that for the UK at the end of the transition period. But generally speaking, the UK will expect you to treat non-EEA data transfers the same as is happening right now, based along the European approach. So you need to understand where in the world, and you can identify that in your register of processing activities, your data is being processed, and make sure that you've got all of the risk factors and the appropriate safeguards identified. And that ties in also with your controllers and processes. So it sort of sits between data sharing agreements, where's your data going in the world, and what who you might be using from a controller, sorry, a data processor perspective as to where your data may be processed. So if you stick all your email addresses in MailChimp, it's going to be processed in the US. Well, what are the implications of that? And when it comes to the use of data processors, you should keep a register or a record of your processors and how you've verified that they have carried out, you've carried out due diligence and that you believe that they're GDPR compliant, and also where you've signed a data processing agreement or some kind of data processing contract, which is binding you both to the requirements of Article 28. Now, the ICO also points out that you should make sure that certain elements of that contract are exercised. So you need to make sure that sub-processors used by the processor, so it's a processor getting another processor to do the work for them, are also covered in what you are putting in place. But in terms of what they expect, the ICO expect from a due diligence check, it's things like making sure that they have appropriate security in place. The ICO even suggests that you should be doing site visits and system testing and data security audits as well. In fact, one of the Article 28 contractual obligations is around a processor allowing a controller to audit them. It's also making sure that you or they, as a processor, depending on the circumstance of the processing, is able, it doesn't stop a data subject from exercising their rights. And also you should be checking that the other party is actually following the DPIA or the contract, so they're sticking to the terms of the contract. Where the third-party processor is an application, so software as a service or something like that, then you're also expected to be able to check that they follow data protection by design and by default as a principle in developing the product and the service. And wherever possible, if you can, minimize data that you share and or consider pseudo-anonymization or full-on anonymization of personal data, then you should be doing that anyway. I'm not quite sure why they've left that to the last thing to do. That's one of the first upfront things I think you need to decide. Do we need to share this personal data? Can we share and achieve the same aim without the data being personalized? Then you should do that. If you can't, then make sure you've got data sharing agreements in place. Make sure that you are aware of any restrictions on where the data might be processed and what you can do to ensure appropriate safeguards. How do you make sure your processes are compliant and so forth? So I think the interesting thing for me here is that the ICO, so the regulation, Article 28, is very quite clear as to what the terms of the contract should be. And one of them is you will, as a controller, have the right to audit the data processor. Now, that doesn't mean necessarily that you can rock up at Google's offices and say, you're processing our data because we store our spreadsheets on Google Drive. Therefore, I'd quite like to come in and see what you're, how you can prove that that is all done securely. The processor can provide other evidential information. They might even carry out external or internal audits of their own, which they can provide to you as a basis of demonstrating that compliance. But it's never been clear whether anybody is actually testing that, testing that contract term. So as a controller, I have a right to come and audit you as a processor, but are controllers actually doing that? I don't really know. And in fact, I wrote an article about it some time ago. Are we expected to be doing this auditing, and what does that actually look like? And there has been some consensual audits, particularly in the health and education sector, where this has been hinted that actually the data controller, the people they were auditing, didn't have enough documentary evidence that they were actually auditing their processes, other than just saying, are you GDPR compliant? Yes, it looks like you are. Can you sign this data processing agreement? So I think that the interesting thing from this element or this category of the framework is this expectation that actually it isn't, as GDPR isn't anyway, a box ticking exercise. It is, you actually have to live by the sort of the gumption that's within the contract and the expectations around due diligence and what that contract stands for. So according to the framework, you need to dig a lot more deeper into what your processes are doing and how you can protect your data subjects data when that's being processed through those organizations. And I think from a processor point of view, if you're a data processor looking at it from the other side of the fence, it's about showing your controllers that you are doing everything right, so that they don't have to ask you, because it's quite obvious where they can find that information. And so, more processors are having GDPR statements and areas of their website that set out exactly the detail that you need to know to prove that you're, that they're compliant. And from a processor point of view, you want to do more of that, because that then sort of deters or distracts the controller away from the need for them sending people in to come do some auditing, although they have that right according to the data processing contract anyway. So that's contracts and data sharing. Data protection is all about risk management in a general sense anyway. So it's not surprising that there's a category around managing risks and the use of data protection impact assessments. The ICO expects you to have an information risk policy in place and to manage the data protection and information risks through your risk register, or even a separate information or data protection risk register if you manage that separately. So that might fit within the expectations of the governments or the governance team that's ensuring you're compliant, led by the data protection officer, for example. You need to make sure that within your organization, so that will be fitting stuff into existing processes for generating new projects, new ways of doing stuff, that you consider data protection at the forefront of the project, not as an afterthought, and that it is part of the key risk considerations of the project, as well as anything relating to any change management that might come through as the product or the project develops. You should have a data protection impact policy, which includes the data protection impact assessment template. The ICO talk about having an initial list of screening questions, and typically, I can't say I've seen these screening questions on their website. They used to have them in their privacy impact assessments, but essentially the screening questions do an initial assessment, and if you answer yes to all the questions or to any of the questions, you have to carry out the full assessment. Sometimes it's just easier just to go for the full assessment, or it's obvious that you would need to carry out a data protection impact assessment and therefore carry out the full assessment anyway. And you need to make sure that your data protection impact assessments are up to date, and that any risks that they've identified that you of course will have had to have mitigated, because if you can't mitigate a DPIA identified risk, you've got to get that confirmed by the ICO. But you need to make sure that they're still being mitigated, and that the risk hasn't come back, or that a new risk hasn't come to the forefront from the processing that might be taking place. So I think, as far as the category is concerned, managing risk and data protection impact assessments, there's no sort of surprises there. I think you know, most people fully get that you need to carry out data protection impact assessments when you're doing stuff for new. Of course, GDPR requires it when there's high risk, but the ICO suggests you do it when you're doing anything new or different with personal data, regardless of the high risk factor. So just document your consideration of what are the risks from the way that we're going to be processing this data, and how do we mitigate those risks and make sure that gets fed back into the underlying project that's leading you along to have to do a DPIA. So that's risks and DPIA. Just 2 more to go. Records management and security. As you can see, this is quite a vast range of different elements of GDPR, ranging from your ability to locate and retrieve records to maintaining the quality of the data, destroying out-of-date data, making sure that you limit control you put controls in place to limit access, and so forth. So very briefly, the key things here, the key themes which you know, are highlighted in that bullet point list, are basically having policies in place that set out how information is classified and how you can get access to it, delete it, and make management of that data easier. You should have an information asset register, so that you understand where your information is being stored, and that kind of, in my mind, ties in with your record of processing activities, because you can record it in there. You should also have a hardware asset register, so you know what devices and systems are being used across your business, who has access to them, who is maybe the owner of that. So if you hand out company laptops, then make sure that you understand which laptop is with which individual, and so forth. Make sure that appropriate security is in place when people are accessing or data is being transferred off-site, as it were. So that might be making use of encryption or VPN services, and also instilling this culture through policies and training about being careful when you share data. If you're sticking in a spreadsheet, why don't you password lock that spreadsheet before you email it, rather than just email it accidentally to the wrong person, those kind of things. Make sure you review regularly. It's not clear how regularly you should be doing this, that what data you are processing is up to date and accurate, and also meets the requirements of your processing, the reasons why you've got the data in the first place. Making sure that you purge any old data that's no longer needed in line with your retention schedule. Make sure that even paper records have an appropriate policy and approach with regards to destroying, whether that's through using cross-shedders to using a confidential wastes supplier. Make sure that you have processes and policies around acceptable use. So typically you should have a data security policy, and that will cover everything from password, hardening networks, through to password security, through to how you make sure that people know what to do when they're working from home, which of course is a key thing at the moment whilst we're in this current lockdown. Have access controls in place, so you're restricting who has access to data to a minimal number of people, and make sure that those access controls are effective from a security point of view. Use multi-factor authentication. That was one of the things that BA got pulled up on with regards to their security breach that they had a couple of years ago. Make sure your passwords are strong enough, and so forth. Keep as many logs as you possibly can for people accessing systems and data, so that you can monitor whether there's anything that's going on that shouldn't be going on. Again, BA were criticised for not having, in fact, most security breaches, when they get enforced by the ICO, usually have some element of nobody actually paying attention to logs or system messages that might be indicating somebody's up to something they shouldn't be doing. So you need to monitor your tech systems, your processes and your services, to make sure that you would be able to spot any vulnerabilities or unusual behavior, like somebody getting access when they shouldn't have. And then it also covers things like, you know, the day-to-day processes, clean desk policies. When well, even working from home, people should be having clear desk policies. Your use of CCTV, devices locking down so that people can't, you know, don't walk away from their desk unless somebody considered it and get access to it. Again, very pertinent with regards to working from home right now. And then finally, have a business continuity plan in place, which has the processes and the protocols in, that set out how you deal with failures in systems. How do you get data up and running again? How do you recover from backups? Have you got appropriate backup schedules in place, and so forth? So again, I don't think there's any particular surprises here. Data security is something that most organizations think about when they talk about data. It's one of a number of data protection principles, of course, but it's the one that lots of people tend to focus on. But that doesn't mean that that prevents breaches all of the time. And so it's about minimizing the risk, doing everything you can to protect the data. Which brings us neatly onto breach response and monitoring. So this is as much about the process of dealing with a breach and having an internal process and procedure that everybody understands, A, how to spot what a breach might be, not be too scared to tell somebody, and knowing who that somebody is so that the breach can be assessed. Any further breaches from the current breach can be minimized, and an assessment can be made about whether it needs to be reported to the ICO if there's a risk, and if there's high risk to the data subjects as well. Those breaches, whether reported or not, need to be documented in a breach register or some kind of log of breaches, and then that should be assessed to see if there are any trends, or whether there are things that have been missed that could be fixed, whether that's a training thing or a policy thing, or you know, people not following protocols or whatever. But the ICO go a lot further than this. Actually, there's an expectation that to prevent breaches, and it sort of ties in with the previous slide about security as well, you should consider internal and external auditing functionality. Now, that may be as simple as doing a self-assessment, like Cyber Essentials, for example, or getting a cyber security company to come and do some penetration testing on your network or something like that. But you're also expected to carry out internal audits following an internal audit plan that I guess ties into the whole breadth of this framework to ensure that you know, breaches are minimized and that security is optimized and so forth. And it even talks about setting key performance indicators on you know, how quickly you deal with subject access or other individuals' rights, how often you deliver training, and whether people pass the test after the training, whether you have you know, you set yourself a goal of not having more than one breach a year or whatever, and yet you've had 10 in the last 6 months. What, you know, what's going wrong? What can you do to fix that kind of thing? And all of this, in fact, the whole framework needs to be overseen by your compliance team or your governance team, and reported back through the data protection officer, who's probably leading that team anyway, to senior management, so that they're fully aware. So that might be once a month, a team meeting is held to address risks, and you having those documented, and considering, actually, you know, we're 3 months away from our annual review and our GDPR training. What do we need to put in place and that kind of thing? And you can maintain your own action list within that team. And then once a month, you also report to the board, setting out, you know, in this last month, we've had no breaches, but we've had to deal with 10 subject access requests. They were a bit close to the wire because we didn't have enough resource, and so forth. So this kind of neatly takes us right back to that first slide. There's the internal governance and the infrastructure that's within the organization. Of course, if you're a small business, then that's probably impractical. But if you're a larger business, you're going to be expected to have a kind of a chain of or levels of input into GDPR compliance that it all pivots around your single point of contact for data protection compliance, or your data protection officer. So that's all 10 categories of the framework. I hope that's kind of given you enough information. If you go to the ICO's website, they break down each one of these in detail, and I've, as I said at the beginning, I've attempted to summarize those so that this wasn't just a death by PowerPoint with tons of text everywhere, although there's obviously quite a lot of text on some of the slides. But it does set out in very neatly, actually, I think, in each of the sections, this is what we're expecting to see, and can you answer yes to any of these questions, in terms of being able to prove that you're meeting the accountability framework's expectations. So what does this actually mean in practice? Well, ultimately, if you're not already, you need to make sure you've got some kind of privacy management program in place that considers the framework obligations, builds that governance framework within your organization, and takes ownership of ensuring that everything is being done that you should be doing. Review your existing compliance right now against the framework and make sure that you're meeting these ICO's expectations, particularly if there's anything I've said or the framework sets out that was a bit of a surprise to you and you weren't expecting that you needed to do it in that kind of detail. Improve your processes and systems where you can, and always remember data protection is ongoing. So improve, review, test, do everything you can to ensure that your compliance is in place, and this framework will help you make sure that's the case. Now, also relatively helpful, although ironically at the beginning in the introduction, the ICO say this is not about a box ticking exercise. What they've actually done is they've produced a kind of box ticking spreadsheet called an accountability tracker, which takes all of the different elements. So this one that I've got highlighted is on this screenshot is a leadership and oversight, but there's a policies and procedures, a training and awareness, individuals' rights, right through the 10 categories. And it's got all of the breakdown of all the things you consider, and you can use this as I think it's a good tool that you can use within your governance or your compliance team to really look at what you're doing. And if there's some ambers and reds in there, then that's the areas that you can focus on. So it'll help you identify some of the things that you're not already doing. So that was everything I was going to cover. That is a real potted summary of the framework. GDPR is a massive subject. It will apply in different ways to different organizations based on the kind of data, as well as the size of the organization, what you're doing, what products and services, what third parties you're using, and so forth. If you've listened to all of this and thought, wow, that's rather a lot, then obviously, and here's the sales pitch, this is what I do. I support businesses with their GDPR compliance. So if you're looking at your this framework, or if you're thinking we haven't looked at GDPR since 2018 when it first came in, maybe we ought to, and let's use the framework as a driver for reviewing, then I have solutions that enable you to work with you basically to help you deliver on that. So have a look at my website, markgracey.gdpr.co.uk. Get in touch, hello@markgracey.gdpr.co.uk. And let's have a chat about how I can help you review, meet the framework, help lead teams to put things in place from a sort of a project management point of view as well. So anything to do with GDPR, I can certainly help you. So that takes us to the Q&A at the end. I've not had any questions in chat as I've gone through. So what I'll do is I'll stop the screen share. I'll stop the recording. We'll go back to traditional Zoom where we can all see each other. And then if you want to ask questions, we can. Otherwise, we'll leave it at that. So just bear with me a second.